This is the audio outline for breach under the doctrine of negligence. Breach of RPP. The defendant breaches the general duty owed to the plaintiff because a reasonable, prudent person in similar circumstances would have done X, but the defendant did Y. Therefore, the defendant breached the duty owed to the plaintiff under the general duty standard because the defendant failed to act as a RPP would have acted in similar circumstances. Please note, always argue breach of the general duty RPP standard, then argue applicable special duty doctrine based on who the defendant is or the defendant's conduct. Then argue negligence per se and BPL, but only if applicable. Only as a last resort, argue re ipsa loquitur if the defendant does not know who did it, but someone was negligent, because these kinds of things don't happen naturally. Negligence per se. Duty is owed to the plaintiff, and breach thereof may be established if the defendant violated a statute. The test to determine is the statute. 1. Defines the standard of conduct. 2. Provides for a criminal penalty. And 3. Meets the statutory purpose doctrine, where the plaintiff is in the class that the statute was intended to protect, and the resulting harm was that which the statute was designed to prevent. Defendant's rebuttal of the presumption of negligence occurs when the violation is reasonable because of the actor's incapacity, or the defendant neither knows nor should know of the occasion for compliance, or after reasonable diligence or care, the defendant is still unable to comply, or the defendant is confronted by an emergency not of his own making or misconduct, or compliance would involve a greater risk of harm to the actor or others. Please note, if the defendant has a sufficient excuse due to rebuttal, the standard of care reverts back to common law RPP. The learned hand formula, or BPL test. There's no duty if the burden or the cost of prevention is greater than the probability times the loss. B equals burden on the defendant to perform duty in order to prevent damage incurred by the plaintiff. P stands for the probability of damage incurred by the plaintiff if the defendant does not act to prevent. L is the loss incurred by the plaintiff. Re ipsa loquitur. In a situation where it's unclear who caused the plaintiff's harm, please consider these 4 elements of re ipsa loquitur. Element 1, the accident causing injury would not naturally occur unless someone was negligent. Element 2, the instrumentation causing the accident was under the exclusive control of the defendant. Element 3, the accident would not have happened if the defendant was using ordinary care. Number 4, the plaintiff did not place himself in peril. Burden is placed on the defendant to prove that he was not negligent. Please note, expert testimony may be supplied but is not necessary because the conclusion may be drawn from experience common to the community or which is a matter of general knowledge. This concludes the audio outline for breach under the doctrine of negligence.